Senator Fawcett.
Thank you, Mr Deputy President. I too rise to address the Defence Legislation Amendment Parliamentary Approval of Overseas Service Bill of 2014. This is the bill that was introduced into the Senate this July by the Greens through Senator Ludlam. And I note that the bill essentially is unchanged from the 2008 bill of the same name, which was also introduced by Senator Ludlam. Just to outline, the bill proposes that the ADF not be permitted to serve outside the territorial limits of Australia, except in accordance with resolution agreed to by each House of Parliament or in accordance with a number of specific circumstances. And the bill goes through to list a number of specific circumstances where members of the Australian Defence Force may serve outside our territorial regions. It does contain some provisions for emergency situations where the Governor-General can proclaim that an emergency exists that may require ADF service, but the essential part is that the proclamation has to go before each House of Parliament, allowing for debate and a vote within 2 days about the vote. Now, the fact that this has its origins in previous bills, and in fact, as the Leader of the Greens has just stated, this stems all the way back to a bill that was put before the Parliament by the Democrats some years ago. And so I think it's instructive to go back and look at the Senate Foreign Affairs, Defence and Trade Legislation Committee, who examined that bill, which was put forward by the Democrats. The inquiry was reasonably comprehensive, and at the time Senator Faulkner was in fact the Minister for Defence, and a number of people, including the department and a number of people from the community and other organisations, made submissions. In the concluding remarks of that report, the committee, which obviously is a bipartisan committee of the Parliament, made comments that those supporting the bill believe that any such decision required debate and approval by the Parliament, but they also acknowledged that in accepting the requirement for both, while acknowledging the critical importance of parliamentary debate, most opponents of the bill stopped short in accepting the requirement for both Houses of Parliament to approve the deployment of Australian troops. They held misgivings about the practical application of some provisions, and I will go to that in terms of practical applications a little later, but I think this bill suffers from the same deficiencies. Since 1986, this is going back to the concluding remarks of that report, when the Defence Amendment Bill of 1985 was debated, a number of shortcomings in the proposed legislation have been raised consistently. So there's a number of things they talk there about whether or not the Parliament's in session, but particularly they come to the issue around the treatment of classified material, as well as constraints on the ability of Defence to mobilise its forces safely and effectively, as well as some problems with definitions. The issue of the disclosure of classified or sensitive intelligence, they went on to say, may well compromise an operation, as well as compromise the safety of Australian forces or those of their allies. The report also makes the point that if, in order to protect our forces or our allies, that information was withheld from the Parliament, then those required under the proposed legislation to make critical decisions about the deployment of forces would not be fully informed, which is an equally concerning situation for the security of the nation and its forces. And the committee found, after some deliberation, that the legislation did not address those concerns adequately.
Stephen.
It went on to say that although the proposed legislation allows for emergency situations, the committee is concerned that the process of seeking parliamentary approval may in some circumstances cause difficulties for the effective and safe deployment of Australian forces. Goes on to say it also has concerns about possible unintended consequences that may arise from including implications of the Australian Defence Force should approval not be forthcoming after forces have been dispatched in response to an emergency. And I notice that this current bill has similar provisions whereby the Prime Minister can advise the Governor-General, who can make a declaration of an emergency, forces can be dispatched, you then have a debate, but then you face the possibility of Parliament not approving, which means that you then have to go through the sometimes dangerous, not to mention logistically difficult act of withdrawing forces who may by then be engaged with an opponent of some kind. It also fundamentally will affect Australia's reliability as an ally in terms of our alliances with other parties, not just the US, but other parties with whom Australia has defence and security agreements. Finally, the report goes on to talk about a range of other activities where Australia does deploy its forces in a situation where they may have to use force, and anti-piracy is a good example at the moment, just one of a number of examples that are laid out in this committee report that talks to the complexity of the legislation and how it would be applied, and why the executive still needs to hold the ability to deploy forces. And the reason I think it's important to go back and reread these reports is that here we have the legislation brought before the Parliament, it's now being debated, and yet this particular piece of legislation hasn't had the opportunity of the review that the previous one did. The previous legislation, which is very similar in nature from the Democrats to Senator Ludlam's last bill to this one, had a number of flaws that were identified that have yet to be addressed from the last committee report, and so I think it doesn't behove the Senate to look at passing this without a similar level of scrutiny and without addressing the concerns in that. To go to the second reading speech by Senator Ludlam, one of his opening statements is he says that Australia is one of the few remaining democracies that can legally deploy its defence forces into conflict zones without recourse to the Parliament. Well, if we look at a number of our allies, that is not actually the case. Here in Australia, it is true that there is no requirement in the Constitution or defence legislation for parliamentary involvement in most aspects of declaring war and deploying troops. The power to make war, to deploy troops and to declare peace are part of the executive power of the Commonwealth, exercised by the Governor-General on the advice of the Federal Executive Council or responsible ministers. Contemporary practice is that decisions to go to war or to deploy troops are matters for the Prime Minister and Cabinet and do not involve the Governor-General or Federal Executive Council. Since the establishment of the National Security Committee of Cabinet in 1996, this body is probably the primary body that has access to all the classified information, briefs from departments who then make the decision on behalf of government. If we look at our allies, this is coming back to the comment by the proposer of this legislation that Australia is one of the few remaining democracies. Let's have a look at Canada to start with. Under Canadian constitutional law, the federal cabinet can, without parliamentary approval or consultation, commit Canadian forces to action abroad, whether in the form of a specific current operation or possible future contingencies resulting from international treaty obligations. Under the Canadian Constitution, the Constitution Act of 1867, sections 15 and 19, command of the armed forces is vested in the Queen and exercised in her name by the federal cabinet acting under the leadership of the Prime Minister. So Canada still essentially has the same executive power that exists here in Australia. Let's go to New Zealand. The formal right to declare war is part of the royal prerogative inherited from Great Britain in 1840, and it remains an acknowledged part of New Zealand law. Defence and wartime prerogatives include the right to declare war and peace and the deployment and armament of defence forces. In New Zealand's case, the royal prerogative is primarily exercised by the Governor-General on advice of elected ministers or executive by authority of letters patent constituting the office of the Governor-General of New Zealand of 1983. If we go to the United Kingdom, this is a case that is often quoted. The deployment of troops and the issuing of orders to engage in hostilities are matters of royal prerogative exercisable by ministers. The government has liberty of action in this field and parliamentary approval is not required. Let's repeat that. Parliamentary approval is not required in the UK. It is usual for governments to keep Parliament well informed of decisions to use force and the progress of campaigns. Now, it is also true that in the UK, since 2003, there have been calls for aspects of the royal prerogative, including the monarch's war powers, to be codified and subject to parliamentary scrutiny. A draft bill to modify the UK legislation is before the House of Lords. It's far narrower in scope than this proposed Australian bill, and the draft bill there applies only to decisions by the government to authorise the use of force by UK forces if the use of force is to be both outside of the UK and regulated by the law of armed conflict. The UK bill also includes key exceptions for emergency security and special forces. Despite there being no legal requirement to consult or seek approval, the Cameron government has sought in principle support from the House of Commons for United Kingdom military action against the Syrian government in 2013. So this was a decision that the Prime Minister made. In that case, he was defeated and he accepted that advice. But the point is that whilst he used his discretion to do that, the claim that Australia is one of the few remaining democracies where the executive has the power to commit forces to war is just clearly not correct. To go to the United States Constitution grants to Congress the power to declare war, to raise and support armies and to provide and maintain a navy. That's Article 1, Section 8, Clause 11. And while the President is made the Commander-in-Chief of the Armed Forces under Article 2, Section 2, Clause 1. The specific power to deploy US Armed Forces is covered by the War Powers Resolution of 1973, also known as the War Powers Act. Now, the War Powers Resolution imposes on the President an obligation in all possible instances to consult with Congress before introducing US Armed Forces into hostilities or into situations where imminent involvement in hostilities is clearly indicated by the circumstances. Now, the terms, and this is where it gets messy, the terms in every possible instance and consult are not defined by the resolution and have been interpreted in different ways at different times by different parties. Notably, the term consult does not equate to the approval of Congress, which is what is contemplated by this bill that the Senate considers today. Many US presidents have claimed that the War Powers Resolution is an unconstitutional infringement on their authority as the Commander-in-Chief and have refused to be bound by it. The US courts, likewise, have been reluctant to accept jurisdiction in matters seeking to enforce the resolution, asserting that it is a political rather than judicial matter. In one case, in 2003, a judge of the District Court rejected the contention that the President must have congressional authority to order American forces into combat, saying, "Case law makes clear that the Congress does not have the exclusive right to determine whether or not the United States engages in war." So I just run through those cases because the opening premise of this bill before us is that Australia's allies, or that Australia is one of the few remaining democracies, therefore the implication is we're one of the few amongst our allies, where the executive has the legal authority to deploy forces to war. But if we look at comparative nations with whom we have close defence ties, being Canada, the United Kingdom, the United States and New Zealand, you can see that the executive does indeed retain the right to deploy forces without having to go back and seek congressional or parliamentary approval. One of the key concerns that has been raised in the committee report that I referred to earlier is the issue of the competence of the Parliament to be engaged and involved in these decisions. Just the contribution by Senator Milne before, in a very minor way, illustrates this. She quoted from a book by Major General Cantwell, and the very fact that, a very superficial thing, but the difference between a major and a major general is substantial, but it just points to the fact that unless people have had an involvement in defence-related matters, it's easy to not understand the import of language, terms and considerations. And so whilst at a broad level I understand that the Parliament has an interest in what is occurring, has a moral obligation to hold the government to account, for the Parliament to be involved in the executive decisions around the use of force, I have some deep concerns with. The other question is, as people often at the moment in this debate are pointing back to the Iraq War, one of the questions has to be, would parliamentary debate have made a difference, both in terms of whether forces were deployed and more particularly the outcomes that were achieved? Even if the Parliament had agreed to the deployment of forces, the thing that most experts look at with the outcome in Iraq post the military action was the fact that the decision to remove the Ba'ath Party and all of its structures removed governance within Iraq, and that it was that power vacuum that was created that has led to much of the dysfunction. And so I, along with many other people, agree with that. But it raises the question then, if the Parliament had given approval to deploy forces, we wouldn't have had a different outcome because that was a follow-on from the actual action. The logical question then is, how much further, how more deeply do parliaments become involved in the strategic, operational and tactical decisions of armed forces in terms of how they approach the issue? You could argue that requiring a plan for post the war is a very strategic level, but it does open up a grey area as to how deeply do parliaments try and reach into decisions beyond the decision to commit troops into then what do they do once in theatre, how do they act? And I think we've seen in conflicts in the past poor outcomes on the ground, and Vietnam is a case in point where there was a lot of political interference in how that war was fought, as opposed to setting a clear military objective and then allowing the military to use the most effective means to achieve the outcome. So it's a very grey area that this bill opens up in terms of what is the role of the Parliament if it were to start getting involved beyond a decision to actually deploy the forces, because I think Iraq proves that we wouldn't have had a different outcome there if the Parliament had approved the deployment, unless they were also involved in the subsequent decisions about how the war was actually fought. Mr. Acting Deputy President, I think it is important that we don't remove from the executive the powers that they currently have on the basis of false assumptions. The assumption that our allies and other democracies don't give the executive this power is not correct. There has been a consideration in detail of similar bills that have been moved by the Democrats and by Senator Ludlam in the past, and the consideration of committees from multiple parties have reached the conclusion that the bill should not be supported. In the absence of details that address the concerns of those committees, in the absence of further detailed consideration, I cannot and will not support this bill.